Welcome back to another episode of Office Hours, where you learn how to be a better law student or practitioner or just something else related to the law. My name is John. Lindsay's name is Lindsay.
Hello.
Support from the show comes from Hemmat Law. Whether you need a good attorney or want to join a fantastic team, go to hemmatlaw.com/GWP. We will be very happy to talk with you more. Also, support for the show comes from Quimby. You guys know the drill. More coming at the end of this episode when we run LTBE.
Oh, yeah.
Lindsay, how are you doing today?
I'm doing good. We got some really genuinely good questions here. I feel like, I'm probably going to end up saying that every single office hours time.
So for a little bit of context, I get DMs from law students and legal practitioners. I do a little bit of law firm consulting. I give talks on how to run better law firms. I also run the day-to-day operations of a law firm myself.
John's hella out there.
Yes, so we synthesize the best questions we get every single week and read them here on the show. Lindsay, what's our first question?
Yeah, we'll dive right into it. Number 1. Hey, John. I am a partner at a 20-attorney firm in Chicago. I've been listening for about a week now. Thank you for listening. With the Trump administration's increasing attacks on the independent rule of law and most attorneys nowhere near the federal practice that is dominating the news cycles, what can us ordinary Joes do to preserve the rule of law?
I think this is a question I've been grappling with because it's true. By volume, like 95% of attorneys do not practice at the elite level necessary to be involved in this impact litigation. And I think the truth is most of us serve clientele directly on the ground. We serve mom and pop. We serve small businesses. Medium businesses even don't have the power to really stand up here. And so a lot of the attorneys I know and several who have reached out to me are really grappling with like, hey, if courts can just be controlled from the bottom up or from the top down, then every judgment I've ever earned from my clients, every procedure I've relied upon to seek justice and defend myself and make good positive change in the world will be worth nothing. And at the same time, they're like, but I do trust in estates, litigation in Moscow, Idaho, right? Do you think what's going on in DC, do I have any power to influence that? And I think we do, but not in the form of like ACLU's got us covered, Southern Poverty Law Center, Anti-Defamation League. There's a bunch of gigantic, relatively powerful nonprofits that are going to do that impact litigation that have really good attorneys. What we need to do that I have not seen enough attorneys doing, partners, and we've seen a lot of associates, but not enough partners and leaders in law firms, step up and go out into their community and be like, hey guys, the rule of law, as frustrating as it sometimes is the single greatest civil liberty, collection of civil liberties we have ever had in the history of the universe. The Western democracy is not an organic, like in the scope of human history of 10,000 to 20,000 years of human civilization. We've only had anything like due process for like 300 of those, maybe, right? Depending on how you count. And most people just don't know that. They were only born between 1 and 50 years ago. And so they don't know what it was like to be an outlaw. And when I say outlaw, I don't mean criminal. All right, that was what was so scary. Like, I disagree with people about Jim Crow. What was so scary about Jim Crow wasn't just the discrimination and like people looking at you funny on the street corner, is that you were outside the law. That's the original meaning of outlaw. When you were declared an outlaw in the Wild West, people could take anything from you. They could injure you. That you forfeited your rights to the title system to own property. You couldn't go to hospitals or seek medical treatment. You couldn't pass property along to your descendants when you passed. You couldn't seek any number of redress that like people take for granted. And that was what Jim Crow was. That was what was actually so scary about Jim Crow, is that none of those things were available to so many American citizens. And I'm bringing up Jim Crow here because that was one generation ago. The daughter of like the Little Rock Nine, who went to school after Brown v. Board of Education came down in this country, she's our age. She's 27. All right. The first daughter, not like the great granddaughter. That guy grew up, had a daughter, and he's the age of my dad.
That's crazy.
And so we've made it like maybe a quarter generation since that happened, and we're already backsliding. So you need to get out there and tell people this stuff matters, right? Vote in local elections. Don't be apathetic, and put your name on the line to defend this, because I'm looking at a lot of these major law firms sort of skulk away into the shadows. And I'm going to remember that because like I do business with some of these law firms because we're big enough that we sometimes associate with counsel for some of our more complicated cases. This matters, right? And I think you need to get out into your community and tell your employees that too, right? Associates are standing up far more frequently than partners at these big law firms because they have nothing to lose, right? And so it's like, on one hand, I admire them. On the other hand, the people who have real influence are at the top of these law firms. That's why Gossip Without Prejudice exists here at Hemmat Law, because our leadership wants to get out there and do something, and this is the best way we know how to make change. I hope you can like get out into your community, but the fact that you're wondering about this and putting in a question to us means that you're already ahead of the curve. So thanks so much for the question.
Yeah, thank you so much for that.
What do you
one.
think, Lindsay?
Very well put. Very well put, John. I fully agree with you, even outside of the perspective of legal practice. As myself, someone who is not a lawyer and does not plan to be a lawyer, it's really freaky sometimes. And I truly wholeheartedly agree that just standing up and speaking about it is the most effective thing that you can do. And so that's another reason why I want to very heartily thank our listeners for being here with us.
Yeah, amen.
Amen.
And just talk to people, right?
Yeah.
The legal industry.
Even if you disagree, that's okay.
Yep.
Talk it out, figure it out, respect each other's point of views, learn something. Learn.
The legal industry, we fall into this trap of where like everyone's disgusted but no one says anything. Say something. And it takes courage, and it sucks, and it might even hurt your bottom line on the short run. But if you get through it, you will also be positioned to be one. I mean, there's actually some big law firms who got their start representing people during the Red Scare from Senator McCarthy in the 70s and 80s, who took on like hundreds of federal employees who were subjected to like loyalty committees, whatever those mean.
Jeez.
We should do a full episode on that later. And they stood up when it was not at all clear it was a good idea, and they stood up for free, and then they got giant because of it. So yeah, man, stay strong.
Stay strong.
What's the next question, Lindsay?
On to our second question for today.
Okay.
Hey, John, solo practitioner here. I'm thinking about expanding my practice, and I have a bit of money saved up to hire an associate, but I am nervous to pull the trigger and take on additional expenses. What can you tell me that might put my mind at ease?
Okay, if you're good at making sales, you're going to be fine, right? That's ultimately all that matters. Is you're going to be fine. But the mistake that most practitioners make is that they wait for them to have the business. They try to most businesses is they expand their infrastructure and then they go after the business they need to run it, right? But what lawyers consistently try and do is they try and get all the business they need ahead of time, and then once they're overloaded, that's when they bring in the person. So they do it backwards, right? The leap of faith sucks, right? There's no way about it. But once you make that leap, you're going to feel a lot better. But this might be a little bit of a misdirect. If it's just a solo practice, you may have a receptionist or a paralegal. The lowest hanging fruit is if you don't have a receptionist or paralegal, don't hire an associate until you have that support, at least one support staff in place. Most attorneys, their biggest struggle is answering the fucking phone. Answer the phone and you'll increase your odds of survival by 60%. It's just such a low bar. Most of your competitors don't do it well. That means if you do, you're probably going to be fine. This assumes you're good at sales. But if you're a solo practitioner and you've been doing it for a while, chances are you are. You know your stuff, your subject matter expertise matters. Get a website and the rest will come out in the wash. And it's never been easier to start a service-based business, man. Entrepreneurship, I love this. I don't own Hemmat Law because I'm not an attorney yet. But the ability to go out there and make moves to run a business more efficiently, I find it super fun, right? You got to kind of have the heart for it. If you don't find the paperwork to run your law firm now fun, and what you want to do is more law, I might encourage you to not do this because the paperwork is on an exponential curve. Pretty soon you'll be trying to run your cases and run your business, and it's going to make you miserable if you're trying to do both. My advice after you hire that associate and get them running and they're competent for a year is to hire a firm manager and hand as much of the admin off to the firm manager as you can. Don't try and juggle both. Or vice versa. Once you got that associate up and running, give them all the cases and you do nothing but the admin. But either way, don't try to have your one eye on two balls. You're going to fail. You're human. Law practice is complex and business is complex. Stacking complex on top of complex will burn you out. It's tough. A lot of attorneys, we're people, we're stressed, and they don't know what direction to turn. So they sort of just face plant or muddle along, and they hate themselves and they turn into jerks because subject any good person to chronic stress long enough and they will turn monstrous.
Yeah, absolutely.
Which I'm not saying you're monstrous, but just watch out. It's what I absolutely hate here in Washington. Most family law attorneys are very toxic people. We treat each other terribly beyond necessary in our adversarial system, and we hold grudges that we don't need to. And I really don't fucking like that. I think that's mostly because we don't know how to run businesses and everyone's really stressed out all the time. And the rest is that we're just more interested in being right than we are having friends and family. And over time, that does things to people that is not healthy. But yeah, man, great question. I think what's on my mind this week, I think if we had to pick one thing, I've been really looking into like ChatGPT and agents for administrative processes. The new ChatGPT image processor that came out this week, incredible static asset generation. I've been generating some really like unique stuff, advertisements, print advertisements, web page mockups. It's been very cool. I'm really worried for like what this will do to like static asset designers in the next 10 years. Because if it's already really good now, oh my God, like I think there's fantastic capital in AI, not for running your cases. I'm very skeptical of legal AI, but like for non-confidential information, I'm absolutely all for leveraging AI use. It can really, really make a business run a lot leaner. Yeah.
Well, there you go. There's some tips and tricks for you. Hopefully that eased your mind a bit.
You know what else eases my mind, Lindsay?
Is it bar questions?
Yes, it is. It is Lindsay Takes the Bar Exam, where we have Lindsay with no legal knowledge take the bar exam every single week. This is question regarding constitutional law.
Ooh, okay.
So we're doing a constitutional law this week. Lindsay, are you ready for your bar exam question?
I am truly ready to give it my best shot.
Okay.
That's all I got.
This is Lindsay Takes the Bar Exam, where we ask Lindsay to take bar exam questions. Here's your question, Lindsay.
Okay.
A mining company owned a small town in state A. Private individuals owned the town's residences and businesses, but the mining company owned the streets and sidewalks and operated the town government. A town ordinance prohibited distributing literature or other materials on the sidewalks without a permit. A town resident was distributing religious literature on the sidewalk without a permit. A town official told her to stop, and she refused. The official then called the state police, who arrested the resident. The resident sued the town and challenged her arrest as a violation of her First Amendment rights. The town argued that as a private entity, it was not bound to comply with the First Amendment. Which one of the following conditions, if true, would support a finding that the arrest violated the resident's First Amendment rights?
Whoa. Off the bat, folks, I have no clue, and this is so interesting. What are my answer options, please?
Your options are A, the mining company was performing a function that traditionally was exclusively reserved to the government. B, the mining company was formed under and subject to the laws of State A. C, the mining company conducted business nationwide and thus affected interstate commerce. D, the mining company's permit ordinance mirrored State A law.
Interesting. Okay. Right off the bat, my tendency is to lean towards A and B. That these laws are here. Anyways, can you please reiterate answers A and B for me? What are those again?
The mining company was performing a function that traditionally was exclusively reserved to the government. And D, you said? B, my apologies. B, the mining company was formed under and subject to the laws of State A.
Yeah, all right. So the first point is this business owns these sidewalks and these streets.
Well, okay, so here's the fact pattern.
Okay.
Private entity owns the town.
Owns the town, okay.
Owns the town and runs its government, and introduced an ordinance prohibiting distributing literature or other materials on the sidewalks without a permit.
All right. I'm leaning towards B, where this town was founded under the laws of this state. And so the laws of the state would supersede any that this town decided to put into place, is what I'm thinking. And I'm not sure if it's worth more consideration or if I should just lock in my answer and go for it.
Just remember, the question
yes, please,
is which one of the following conditions, if true, would support a finding that the rest violated the residents' rights.
All right, beautiful.
So it's a different question than usual.
Which of these, if true, is the reason that she can sue successfully? Ooh, this is interesting. I'm sticking with B though. I think that makes the most sense in my layperson's head of the law of the state supersedes that of any that a private entity would put on a town. That's my guess. I'm locking in B. That's it.
Locking in B.
Locking in B.
I'm gonna start with the correct answer.
Oh, the master of suspense.
The correct answer is A.
Damn it!
With-
I was so close.
94% of respondents answering A.
Oh, so I really should have gotten that one.
The mining company was performing a function that traditionally was exclusively reserved for the government.
Yeah. Okay.
So what's happening here is with 3% of respondents answering B, the mining company was formed under. So the mining companies and people are formed under and subject to the laws of the state they're in anyways.
Right.
All the time.
Yeah, okay.
So the mistake you made was that here, normally private corporations and entities and people are not bound by the amendments of the Constitution or
Okay.
any tenets of the Constitution because they're private. The Constitution constrains the government, right?
Okay.
And divides its powers and privileges. But here, this private entity had subsumed the role of the governing body. And so when that happens, the private-public partnerships, when an essential function traditionally exclusively reserved for government is subsumed by a private entity, that private entity takes on the restrictions of the Constitution.
So it, technically speaking, this would go against her First Amendment right.
It wouldn't be technical; it would.
That's cool.
Because it was
Interesting.
the mining company owned the town, ran the government, passed the ordinances, and then restricted religious leaflets being handed out without a permit, right? And those are all traditionally very basic protection, freedom of speech, freedom of religion. And so First Amendment rights were violated, should not have been arrested.
Cool.
Answer is A.
Wow. You know, I'm a little disappointed that I didn't get it right, but mostly I'm glad that
Yes.
system is set up the way that it is.
Because otherwise what would happen is the government could just subcontract all its roles to private
Yeah,
organizations,
and
and then
then-
those organizations could just do whatever they wanted to
That
anyone.
would be
And so
awful mess.
courts have actually spent a lot of time examining situations like this and going, is this contractor now essentially a state actor? And if they are, therefore, should they be subject to various restrictions and responsibilities? So like when the government contracts, there have been situations where if a private public partnership had a private entity seizing property or purchasing property at en masse that impact communities, courts would come in and examine whether or not it was acting as a state actor or whether or not they were private, and that can impact the downstream analysis. So this is this was an easy question.
Yeah,
This was
that was an easy question.
a fundamental facet of the system, and that's why this is so important to constitutional law,
Yeah.
so that people can understand that private entities can be bound by the Constitution when they are acting as a government proxy. That's the
Beautiful to
takeaway for this
know.
question. Yes.
Beautiful.
And very good too. That's part of why company towns were so tyrannical back in the
Yeah.
gold rush era, because these companies, that was before this doctrine was effectively enforced. And so companies would, for those of you that do not know what a company town is, usually mining or railroad companies would go to extremely remote areas, build an entire town with all its infrastructure, and then ship usually Chinese laborers or poor people in from out to work the local coal mines or whatever have you. And the mining company, there was no local economy. It was just the company that owned and ran everything. And instead of money, they paid you script or company script, and that script was basically a proxy currency. You could, the general store was run by the company, the day court care was run by the company, the clinic was run by the company, and then the company would charge you its own fake money to receive essential services. And that's why these places were so hellish, is because they were allowed to operate as private. They had various problems. They treated their workers terribly. Many people died, particularly in Appalachia. Coal mining towns were notorious for this. And the labor movement was actually born of conservative laborers standing up and saying, hey, we shouldn't be treated like this anymore.
No, this ain't cool.
We should talk about the Pinkerton Detective Agency, a national detective agency. They're still around, but there's actually a federal statute. They're the only detective private security company that has a federal statute, and all the federal statute says is that the feds can't hire Pinkerton Detective Agency. And that was partly because of their strike-breaking operations during the robber barons era. Anyways, that's my tirade on private, company towns and private
And Monopoly books.
Monopoly books and Monopoly money and all sorts of other things.
Love it.
Did that make sense, Lindsay?
Yes, it did.
Okay.
Indeed, it did.
Perfect. That has been another week of LTBE. I hope you enjoyed joining us for office hours.
Hopefully you got the question right.
Yeah, hopefully you got the question right. And if you didn't, 94% of people responding to this question would disagree.
Including me.
Yes, exactly. But this was an important lesson. It's going to come in handy
Yeah.
for constitutional law later.
Definitely.
Everybody, only about 30% of our viewers who listen to this show regularly are subscribed or follow us on any channels. Please do us a huge favor. Subscribe, hit all the buttons you like, show this show to a friend. It would be a personal favor to me and Lindsay. Go to gospel.prejudice.com. Pledge as little as $5 a month can really keep the lights on, help us out. You can join our exclusive community, get bloopers if they happen, extra, get to vote on future content, a bunch of other extra goodies that we're still working on pulling together. But I greatly appreciate your time here. Thank you so much for joining us, and we will talk to you very soon.
Thank you so much. Bye.